Welcome to Talking Business, your straight talking guide to dealing with corporate matters. Whether you are a private or public company, an owner managed business or an entrepreneur, a director, company secretary, or in house counsel, this is the podcast for you. My name is Sophie Brooks, and I'm a partner in our corporate team. I was a transactional lawyer for a number of years before becoming a professional support lawyer, which means I'm now responsible for know-how across our corporate team. Hi everyone! So this month I've got a key case for you that provides a bit of a salutary lesson really for directors about misfeasance claims, as well as a look at how the UK's national security regime for reviewing transactions is operating, and then also news of the creation of a new class of personal property that we're going to have. But first up, I've got some news about the latest developments under ECTA, which I've talked about before. You might remember it's the Economic Crime and Corporate Transparency Act, which is very much aimed at combating economic crime, preventing the abuse of corporate structures. So a key part of that Act's reforms is understanding exactly who is filing information at Companies House on behalf of registered entities, so things like companies, limited liability partnerships, that kind of thing. So the latest development is there was a blog post by Companies House talking about some detail on the process that organisations such as accountancies, lawyers, company formation agents will need to go through in order to register as what's called an authorised corporate service provider, so an ACSP. And so that registration is going to be required before an organisation can file information at Companies House on behalf of a registered entity. So, like I say, it's another measure that's coming in under ECTA, and Companies House are going to be required to verify the identity of anyone submitting information to the public register. So that could be done by a verified director of the relevant company, but lots of companies use third parties, like I say, could be lawyers, accountants, formation agents. They use those service providers to file their required information on their behalf. And it's those third parties that are going to need to register as an ACSP in order to continue doing that. Only organisations that are covered by the money laundering regulations and are supervised by one of the relevant anti-money laundering supervisory bodies will be able to register as an ACSP. So this blog post from Companies House gave us a little bit more information about the registration process, and it indicates that that process should be completed by somebody senior within the relevant organisation, so someone like a director, and that person will have to have their own identity verified as part of the process. And then once they have registered their organisation as an ACSP, that organisation will be provided with a digital account and identity number, and that's the thing that will allow them to then file information at Companies House, as well as complete identity verification checks as well if they want on behalf of their own clients. Now, the registration process isn't open for applications yet. We also had recently the Companies House business plan for 24-25, which indicates that individual identity verification for directors and PSCs, persons with significant control, is going to be rolled out from March next year, March 2025. And registration of ACSPs is basically an important precursor to that process of identity verification for directors and PSCs. So because of that, I think we can anticipate that the registration of ACSPs will start hopefully later this year, 2024, or very early 25, so that we're all ready for when those new requirements are rolled out from next March. So if you're an organisation that files information at Companies House on behalf of somebody else, your clients, then you should begin preparing for the registration process now. So an appropriately senior person really within your organisation should be given responsibility for managing the process, including collating all the information that you're going to need for that. So that will include things like the organisation's anti-money laundering supervisory body membership number, as well as information to verify the identity of the individual who's overseeing the process. And then keep an eye out for other announcements from Companies House so that you can get registered in good time to enable you to continue submitting information to Companies House on behalf of your clients. And there's going to be a lot of developments in relation to ECTA, the Economic Crime and Corporate Transparency Act, over the next sort of 6 months or so. So, for all things ECTA related, check out the ECTA hub that we've got on our Gately Legal website, which is constantly updated and is a good reference source for all the changes that are going to come into force. Okay, so next up, then, I mentioned that we've had a key case in relation to directors. So, this is the latest stage in the long running litigation relating to the collapse of British Home Stores, BHS. And it's culminated in the High Court ordering two of the group's former directors to pay compensation of £110 million for breaches of what we call the creditor duty. So those breaches resulted in the group continuing to trade at a time when it should have been put into administration. And it's referred to in this case as misfeasance trading. So that's what we're talking about here. So it's a pretty landmark judgment. It was a very long judgment as well, which provides useful lessons really for directors of distressed businesses. And actually, this decision was the first recorded time that the courts have set out how they will calculate the compensation payable by directors for these types of misfeasance claims. So, what are we talking about here? What are these misfeasance claims? Well, if a company enters a formal insolvency process, so I'm talking about liquidation, administration, then the office holder, so the administrator, the liquidator, can bring a claim against the company's directors for misfeasance, and it's a claim under the Insolvency Act. So, misfeasance here is very broadly defined, but an action can only be brought where the officer, the director, breaches some form of duty that they owe to the company in their capacity as a director. And to succeed with a misfeasance claim, the applicant must show a loss to the insolvent company that was caused by the relevant breach of duty. And if the misfeasance claim is successful, then the court can order the director to compensate the company for the breach of duty by way of a contribution to the company's assets. So the background to this latest decision is that earlier in the year, in June, in fact, the High Court ruled in favour of the joint liquidators of the BHS Group, and they'd brought claims against the former directors of those companies for wrongful trading and also for misfeasance. So the individuals that we're talking about, they'd been appointed as directors of the four companies in the BHS Group following the group's acquisition by a consortium company. And a year after their appointment, the directors resolved to put the BHS Group into administration, and each company then subsequently entered a creditor's voluntary liquidation. So, in that June ruling that we had earlier this year, the High Court found two of the former directors liable for wrongful trading and ordered them to contribute £6.5 million each to the assets of the BHS Group. Now, the directors were also found liable for misfeasance on the basis that they'd breached various of their statutory duties under the Companies Act. And the main duty that we were talking about is this one that I've referred to as the creditor duty. And that refers to the requirement for a director to consider the interests of a company's creditors, in addition to its shareholders, when exercising their usual duty to promote the success of the company in circumstances where the company is insolvent or bordering on insolvency. So if your company's in that situation, you've got to think about the company's creditors, basically. And the court held that if the directors had complied with that creditor's duty, so if they had thought about the creditors, then the BHS companies would not have continued to trade and they would have gone into administration sooner than they did. Now, in the June ruling, because of the amount involved and the fact that the judge said it was a developing area of the law, they didn't make a decision at that stage in relation to the director's contributions for breach of duty and the resulting misfeasance trading. That was held over to a later hearing in order to allow additional submissions to be made. So, this latest decision now sets out the conclusions that have been reached on these particular points. So, the judge agreed that the correct starting point for assessing a director's contribution for misfeasance was the total increase in net deficiency of the company's assets resulting from the relevant breaches and the company basically continuing to trade after it should have been put into administration. So, what was the effect? What was the deficiency in the company's assets? How much were the company's assets reduced by as a result of that decision? So, in this case, the BHS directors were found to have breached the creditor duty on two separate dates when they had authorised the group companies to enter into new finance arrangements with particularly onerous terms in them. And the total increase in net deficiency between the first of these dates and then the date that the company subsequently went into administration was about £133.5 million. So that was effectively the difference between the group's assets and liabilities at the point the companies entered into the additional loans and the point at which they went into administration. But for the directors to be liable for that full amount, so £133.5 million, the liquidators had to establish that the directors' breaches of duty were the effective cause of the losses suffered by the group. They didn't necessarily have to be the sole or the only effective cause, but it did have to be the effective cause. And here the court found that, with one exception, which was to do with a £19 million company pension deficit, the directors' breaches of duty were, in fact, the effective cause of that total increase in net deficiency. So, if the directors had complied with their duties and therefore taken into account the interests of the creditors at the time, the companies wouldn't have entered into the financing arrangements and would instead have gone into administration at that time. But by continuing to trade, the increase in the net deficiency, that was what occurred by not taking the decision to enter into administration at that earlier date. So, after making the necessary adjustments, the court held that the total compensation payable by the two directors was £110 million. And the directors were held to be jointly and severally liable for that amount. And in fact, the judge declined to exercise any discretion to apportion liability between them. So, obviously, that case provides a pretty stark reminder, really, for directors that they can be liable for misfeasance at an earlier point in time than for wrongful trading. And that time difference can have a very significant impact on the compensation payable in relation to each of them. Remember, their liability for the wrongful trading claim was assessed as being £6.5 million each, which is obviously far less than this £110 million liability for misfeasance. So the directors in this case were found to have breached the creditor duty with that resulting liability for misfeasance almost 3 months before the threshold for wrongful trading had been met, i.e., that threshold being the point at which they ought to have concluded that insolvency was inevitable. And the lower threshold, I think, for the creditor duty to be engaged might lead to us seeing more claims for misfeasance in the future rather than wrongful trading, because that can come in earlier and therefore potentially result in a greater recovery for the office holder bringing the claim. Now, crucially, directors do have a defence for a misfeasance trading claim if they can show that they considered creditors' interests in good faith and concluded that it was in the creditor's best interests to continue trading. So as always, whenever there are potential solvency questions, the directors of the company always need to be thinking about the creditors and not just the shareholders. And obviously, this case is a bit of a reminder about the potential liabilities that could arise if you failed to do that. Okay, I mentioned the UK's national security regime for intervening in transactions, and that's because we've had another report. It's the third report now, actually, um, in relation to the operation of what's called the National Security and Investment Act. This report covers the period sort of for the year up to March 2024, and it provides some useful, interesting statistics on how the regime has been functioning, including things like the number of notifications made and the sectors involved and the origin of the investments that the government has been looking into. So, like I say, we're talking here about the regime under the National Security and Investment Act, which allows the government to scrutinise and intervene in acquisitions and investments in order to protect national security in the UK. So the government can call in and review various transactions that meet specified criteria when they raise national security concerns. And some transactions in sensitive sectors have to obtain clearance from the government before they can take place. There's a mandatory notification procedure. And so you have to notify, and then you can't complete your transaction until you get that clearance. Then, following a review of a transaction, the government could decide to clear it unconditionally. So they say, yes, it's fine, you can go ahead. They could decide to approve the transaction subject to conditions, or they could even block the transaction from taking place. Or, in fact, if it's a transaction that's already taken place, which wasn't notified, then they can actually unwind it if necessary. So this latest report shows statistics, as I say, on the second full year of the national security regime, and it's quite a useful tool, I think, for investors or buyers seeking to understand how that regime is operating in practice. So a few key highlights for you from the report. So there were 906 notifications made in the year, which is up slightly from last year. There were 865 then. The vast majority, so just over 750, were mandatory notifications. There were about 120 voluntary ones. And then interestingly, there were 33 what are called retrospective validation applications. So that's basically where a transaction that should have been notified completed without getting the necessary approval. So there is a process there where if you realise that that has happened, you can apply for retrospective validation. And as I say, we did have 33 of those applications this year. So there were 41 call-in notices issued. So that's down actually from last year. There were 65 last year, but there were only 41 call-in notices last year. And also, interestingly, 4 of those related to non-notified acquisitions. So I think that's a reminder that you can't just kind of keep a low profile and hope that your transaction won't be noticed. The government do review transactions even when they haven't been notified to them. They will be looking at them and they can take action and call them in for review if they want. In relation to final orders, there are only 5 issued this year, which is quite significantly lower, down from 15 last year. So only 5 of those 41 call-in notices had a final order made. And interestingly, again, the government didn't actually block or unwind any transactions at all. All 5 of those final orders were conditional clearances. So they were cleared, but they had some conditions applied to them. In terms of which sectors the government's particularly concerned with, well, no real surprises here. Transactions in the defence sector continue to be the most likely to be called in, and then military and dual use, communications, advanced materials, and then interestingly, academic research and development, all of those sectors featuring quite frequently. In terms of the origin of the investment that the government's concerned about, again, broadly mirroring the last reporting period, calls in most frequently involved investors with links to China and then also the UK. This act isn't just concerned with foreign investment in the UK, it also catches purely UK transactions where one UK buyer is acquiring another UK target. But in terms of non-UK investments, it's primarily China and then the USA. But as I say, there were no final orders imposed on Chinese acquirers, which did occur in the last year. And then the other thing just to flag is some of the timing requirements. So the average time taken for the government to accept a notification was up slightly. And again, that's for both voluntary and mandatory notifications. So just that's gone up slightly. So again, potentially affecting transaction timetables. So in April of this year, obviously before the general election, we had the government published an outcome of its call to evidence on the Act and committed to implementing various changes during 2024. Now, some of those changes have happened, which included things like some updated market guidance. But obviously, since that call to evidence, the response was published, we've had a change of government, and we're not sure whether some of the other reforms that were trailed are actually going to come into effect, or indeed what the likely timetable of that might be. There were some proposed changes to the definitions of the sectors, and interestingly, some possible exemptions, particularly relating to, if you like, intra-group transactions where there's no change in the ultimate beneficial owner. At the moment, those kind of transactions are still caught by the regime, and it was hoped that there would be some exceptions for those. But like I say, we are still in limbo with that and waiting to see whether the new government is going to pursue that. Okay, and then finally, I mentioned the fact that got some new legislation which is going to create a new class of personal property. And this is all designed to cover digital assets in particular. So, those assets or certain types of digital assets are going to be considered personal property, and therefore they'll be given the same kind of legal protections as the existing classes of personal property. So this has all come about, obviously, because of the expansion and use of digital assets. And because of that, the government asked the Law Commission to consider how the principles of personal property law could apply to those assets. Because basically, there were concerns that without greater clarity and understanding in that area, the status of those potentially very valuable digital assets would be uncertain, particularly in matters such as bankruptcy or insolvency, succession on death, or even theft. So the point is that traditionally, the law has recognised two broad categories of personal property. So these are things in possession, so tangible things that can be physically possessed, so a car, for example, and then things in action, so legal rights or claims that were enforceable by court action. So, for example, a right to sue for a debt. That's a thing in action. But there was a concern really that digital assets didn't easily fall into either of those existing categories. So they're not tangible, you can't hold them, so you can't really categorize them as things in possession, but neither can they be considered things in action in the narrow sense. And in fact, some crypto tokens are explicitly designed not to consist of a legal right or claim against a person. So, because of all of that, the legal status of these digital assets and therefore the rights of those people that claim to own them were uncertain, leaving those owners in a grey area if the assets were interfered with. So, when the Law Commission looked at this, it published a report that recommended creating a third category of thing to which personal property rights can relate. But interestingly, the Law Commission also said that the relevant legislation shouldn't define the boundaries of that third category, and it should be left up to the courts to develop it via common law. So the result of all of that is that we've got a new bill. It's called the Property Digital Assets Etc. Bill, and that's been introduced to Parliament. It's a really short bill. It basically just has one real operative provision, which says that a thing including a thing that is digital or electronic in nature, is not prevented from being the object of personal property rights merely because it is neither a thing in possession nor a thing in action. So, what it basically says is just because it doesn't fall into one of the existing categories doesn't mean it isn't personal property. So, like I say, it doesn't provide that any particular thing will be personal property, but it does make clear that just because it isn't a thing in possession or a thing in action doesn't prevent it being personal property. And so that leaves the possibility open for the courts to develop that category over time, including, sort of where the boundaries of it sit and what rights attach to this new third category of thing. And also, although digital and electronic things are specifically mentioned in the bill, the new third category isn't limited to that kind of thing. Like I say, the name of the bill is digital assets, etc. So again, that leaves open the possibility of the courts finding that non-digital things also fall into this new category. So the new law will essentially give legal protection to the owners of some types of digital and electronic assets. They will be able to take action if there is, in the event of fraud or theft of those assets, and they'll be able to use legal tools like injunctions in order to protect them. Digital assets could also form part of the owner's estate on their bankruptcy or insolvency, so they could be resold to repay the person's creditors, or they could form part of their person's estate on their death when they could be bequeathed to beneficiaries. So the term digital asset, obviously a really broad term. It covers a variety of different things. So things like digital files, digital records, email accounts, digital carbon credits, crypto assets, non-FTs, non-fungible tokens. But the Law Commission's recommendations only apply to a particular subset of digital assets, of which the main one really is crypto tokens. So the UK is actually one of the first countries to recognise digital assets in law. And clearly, it's hoped that by doing that, it will give legal protection to owners and companies against fraud and scams, whilst also helping judges deal with complex cases where digital holdings are disputed or maybe form part of settlements, perhaps in things like a divorce case. So definitely a welcome development, I think, in terms of developing a system, a personal property system for these kind of assets. But there are still issues that are going to need to be clarified by the courts. I think it's actually good that the Act has sort of left it rather vague, rather than trying to define a particular class. They've sort of done it in a negative way, if you like. But I think the sort of pace of change in technological developments means that by leaving it open to the courts, that doesn't restrict them. They're not going to have to keep going back and passing a new act to catch a new type of asset. So they've given a lot of flexibility to the courts there. But to assist in that, the Law Commission did recommend that the government create a panel of industry experts that will help to provide guidance on technical and legal issues relating to digital assets and the development of this new class of thing. So that's it for this month. Hope you found that interesting, and I will see you again next time. Thank you for listening to Talking Business. To find out more about the series, please visit gatelyplc.com/talkingbusiness. From there, you can subscribe for all updates, meet our speakers, and get more information on all of the topics being discussed.